welcome back. This is me, Sheila Kololo, your double master's graduate, a junior forensic investigator, currently on secondment as a candidate attorney. So today we'll be starting our journey to preparing for board exams. So we'll be starting with our high court practice today in preparation for our board exams. Guys, just a disclaimer, these videos are not there to supplement your studying. You have to go through your study material, but I'll just be helping you guys run through the lead guide as fast as we can and just summary. So today we are starting from unit 2, which is the beginning of action procedure. For unit 1, each one can just go through that. It's the different types of courts and all that, the most basics of basics, which I feel at this stage as candidate attorneys we should know, or legal practitioners, law students, we should know. So I'm not going to go through that. So we are starting with our action procedure. So before I just jump into that, what is the difference between an action procedure and an application procedure? So in an action procedure, there is a material dispute to the facts which can only be clarified through leading oral evidence. So it is instituted by way of summons, and then there is preparation for trial, and then trial, which essentially then oral evidence is laid. And then the former, which is our application is basically there's no material dispute to the facts. We can deal with everything on paper. We file affidavits and then there is no need to lead oral evidence, because everything can be dealt with on paper. So that's the simplest way of understanding the difference between the two. All right, now our action procedure is divided into 3 stages. So we've got the pleading stage, we've got the preparation for trial stage, as well as the trial itself. So the different kinds of pleadings that we've got in our action procedure, it's the summons, defendant's plea, defendant's counterclaim, plaintiff's reply, plaintiff's plea to defendant's counterclaim, request for further particulars, and then the plaintiff's request to plaintiff's reply to the request for further particulars. So this list is not exhaustive, I believe. So basically any document that we exchange during our pleading stage, we consider that a pleading. And then now moving on to our summons. We've got 3 types of summons in our action procedures. In our action procedure, we've got our simple summons, provisional sentence summons, as well as our combined summons. So how does simple summons look? Simple summons do not contain any particulars of claim. That's your rule number 1. Simple summons just states the nature. There's no particulars of claim. At a later stage, then the plaintiff will submit what we call a declaration. So a declaration serves the same purpose as a particulars of claim in the case of combined summons. So when can you issue simple summons? Simple summons can be issued when the claim is based on a liquidated demand. So what is a liquidated demand? So a liquidated demand is we already know how much is being owed. The amount is very specific. So suppose I do your hair, and after doing your hair, I tell you, so and so, you owe me 70 rand. There is no dispute to that. You owe me 70 rand. It has been agreed upon. We don't need to be raising 1, 2, 3 in order for us now to determine how much the claim is worth. So a liquidated demand is basically having an amount that is agreed upon. You don't need to lead further. There isn't any further issues to raise in order for us now to determine the amount payable or the quantum claimable in certain instances. So that's what a liquidated demand is. So under which circumstances can we now use a simple summon? We can use a simple summon when you're claiming for delivery of movable property. It's obvious. I've got the specific asset that I need delivered. Number 2, the claim is based on a contract. The contract states that, okay, the purchase amount is this, whatsoever. Also, that's quite specific. Transfer of immovable property, we know the property that is being transferred, so there's no confusion in that. Cancellation of a contract, we are just cancelling a contract. And then another one is claim for eviction. You're evicting someone, so those are the instances where you can use your simple summons. Very straightforward. There's nothing that will be disputed or so. We know the value, if there's a value. We know what's being transferred, if there's movable property, or we know what needs to be delivered in case of assets and such. So it is very specific. And then coming to our combined summons, our combined summon can be used for anything. Really, they are not picky, but they have to be annexed with a particulars of claim. So it would be a summons, and then your particulars of claim, which sets out to the facts that you rely upon as the plaintiff. So the major differences between simple and combined summon is that in case of a simple summon, it need not be signed by an advocate. An attorney is sufficient. But then in the case of combined summon, it has to be signed either by an attorney or an advocate, but the attorney has to have a right of appearance with the High Court. So in terms of signature, in case that would come in the exam, you should know that, okay, in the case of simple summons, an attorney is sufficient, but in the case of combined summon, it has to, if it's an attorney, it has to be an attorney with right of appearance in the High Court, or then an advocate. And then the last one, provisional sentence summon. So provisional sentence summons essentially can be issued where the party cannot deny liability, like at all. It's not cannot be disputed. Let's say you've signed an acknowledgement of debt at some point, and then now you come back and say no. Then you would issue your provisional sentence summons. Provisional sentence summon can be used to claim also for a liquidated sum of money or a claim. So this is like also your claims for an ejectment or claim for delivery of a specified immovable property. So a provisional sentence summons is basically very efficient, where the creditor has prima facie evidence that, okay, this person owes me, this is the amount they owe, I've got evidence, cannot be disputed, and now they want to institute legal proceedings and would want to do so with something that is a lot quicker, and judgment can be granted in respect of same. So now they can issue simple summons. Okay, that's it from me, guys. I really hope you found the video helpful. Remember, the video is a summary, not replacing your the need for you to actually go through your study material. I will be sending videos every second or third day, just going through the guide. So I hope you find it helpful, and bye.